Anyone have any questions that they would like to pose? Please.
In ICICI Bank versus
Please introduce yourself first.
What?
Please introduce yourself.
My name is Shyam Patel. I am a student of law, second year. My question is for Karishma Vora. In ICICI Bank versus Mehmeta case, did the court approve take the son who is a Belgian citizen to treat under English court?
Yes, they did. And they did that because of the fact that England is still part of the EU and therefore the Brussels regulations apply. And any court where one of the defendants resides can have jurisdiction. And because England was the court first seized of the matter, therefore they brought all of the disputes within England, including a Belgian citizen. Although it could have even been an Indian citizen in Belgium who would have Belgian residency and the same rules would apply.
Yeah, I'm Suresh Savadia. My question to Karishma Madam. Relating to the subject matter of agreement is immovable property.
Mm-hmm.
Can we have a clause giving the jurisdiction, rightful jurisdiction to court, which is a place other than location of the immovable property?
So in that case, there are a number of courts that will have jurisdiction. The first court that will have jurisdiction is wherever the immovable property is situated. And the second court that will have jurisdiction is where the defendant is resident. And that may or may not be the same as where the immovable property is situated. So you can choose to bring, I'm guessing this is an Indian case entirely, and
yes,
you can bring that case in any one of those two courts.
Other than the place where the
immovable property is situated. Sahil, do you have anything to add?
I'm talking about the court jurisdiction.
I think you would have to go to the court having original jurisdiction where the immovable property is located. I think section 12 or 13 of the CPC, I don't remember exactly, would require you to do that. Happy to discuss this with you after, take this offline and discuss this with you. But yes, what CPC talks about is different ways in which a court gets jurisdiction. Obviously, one of the ways is where the defendant resides. Insofar as immovable cases are concerned, what you will see is it ends up being the court where the immovable property is located. So there is a specific provision in that regard. I hope I answered your question.
Section 2.
Section 5. I'm a little...
Section
12. That's right. Anyone on the call would have any questions for the panel? Happy to take them up.
Sir, if you can
yes, please.
answer I am Parth Jani, I'm a law student. So I have a question that as you concluded that there can be a position that I might be governing under the procedural laws of foreign country, but my substantive law would be in India.
That's correct.
So wouldn't there be any dispute or differences in the adjudication proceeding which would be governed in the foreign country?
Well, practically what you will see happen most likely is that when parties are, let's assume it's two Indian parties and they've decided to have their arbitration in either London or in Singapore, the most common jurisdictions. What you will see is, given that both these jurisdictions are so arbitration friendly, the arbitration will probably go on and it will result in an award. But given that there is a foreign law involved, a lex arbitri, when you try to enforce that award is where you may hit a speed breaker, or it's that aspect of things that there exists a little bit of a gray area on. So to that end, the enforcement of the award may be put into a little bit of a debate. Having said that, we ourselves are aware of a bunch of Indian arbitrations or Indian parties arbitrating abroad where arbitration has gone off smoothly and has resulted in settlement of disputes. So it's not that it hasn't been done, it's just that there is a little bit of gray area, which if a party is going to be entering into an agreement, they should enter into it with their eyes wide open.
CPC be applied in arbitration?
Say that again, please.
Can CPC be applied in Indian arbitration?
So, to what end? CPC governs the procedure before the Indian courts. Arbitration and Conciliation Act talks about Indian arbitration. At the end of the day, courts and arbitration are complementary to each other. They're alternative dispute resolutions. So yes, there is a certain amount of arbitration-related procedure for which you need to go to court. For example, Section 9. For example, Section 34. Section 9 talks about interim relief. Section 34 talks about setting aside. Section 40.
CPC 711, say for example. Section 7,
Order
7
Order 7, Rule
Rejection
11.
of claim.
Rejection of the plaint in arbitration. Can I file an application in arbitration matter?
The reason that parties go to arbitration, one of the reasons is, and one of the more advantages of arbitration is the simplification of proceedings. So one doesn't have to and is not obliged to follow the strict rigor of litigation. So CPC in India or CPR in the UK in an arbitration. And while the overall procedure can be governed, so for example, now you have a lot of arbitration institutions mushrooming in India. The latest is the MCI, the Mumbai Court for International Arbitration, right? So once you have an MCIA clause, then the procedure as set out by the MCIA will be applicable, and then the CPC is no longer relevant. However, if you have an ad hoc arbitration, it's not necessary that the CPC has to be followed in the exact detail that one would have to follow in court. But yes, you can refer to it should you find yourself in procedural trouble in an arbitration.
So just to add to that, Section 19 of the Arbitration Act says that the arbitral tribunal will not be bound by the Code of Civil Procedure. That stands. But when you file an application that is akin to an Order 7 Rule 11 application for rejection of statement of claim, technically the arbitral tribunal will not be looking at CPC principles. However, the basic tenets of law which say that no cause of action can be seen. Okay, no cause of action has arisen, which is one of the principles under rejection of plaint.
Last week on the defendant, the Order 7 Rule 11 application and arbitration. So I was just...
Right, so maybe the form of it is not really binding the tribunal. However, the tribunal can look at certain applications of that sort where it is going to see whether the cause of action has really arisen or not. It is rare because the tribunal is not bound by the CPC. However, it is going to go ahead and adjudicate, maybe at some stage or maybe at the preliminary stage itself.
And principles of CPC are something that every arbitral tribunal will certainly keep an eye on, if not be bound by.
It can also be the equivalent of a strikeout, an application to strike out the claim. But it's just put in the court format, not that the arbitrator is bound by it.
You have a question?
So can you have an arbitral clause to say that you can challenge the arbitral award in a court of law, like in a high court or like a Supreme Court? Is that arbitration agreement valid?
Yes.
Saying that you cannot challenge?
Like you can, because isn't the award supposed to be final and binding?
It depends on what the arbitration agreement says, and this is exactly, so it's how you interpret the jurisdiction agreement, which is the arbitration agreement in this case. It can say that the award is final and binding, or it can say that there will be an appellate body which you can confer, you can decide whatever your appellate body is, and if you haven't, then you can even go and appeal to the court.
So let's ask a slightly
Sahil,
different question on this. So let me ask this question to Karishma. Karishma, we see millions of agreements out there today which say that parties agree to submit their disputes to final and binding arbitration. They say that the award that comes out will be respected by all parties and all parties will not file any appeal against any such award. What is the sanctity of that particular clause in your view?
It's a very good question because the arbitration amendments, the 2015 amendments, have also tried to narrow the ability of parties to appeal from an arbitration award into court. And it remains to be seen because we're still going to now get into the phase where we have awards emanating under the new Arbitration Act. And it remains to be seen how the court will interpret that. But it's been specified, if I'm not mistaken, in the amendments, the three fundamental propositions by which one can appeal. Of course, it must be a point of law, and it must be against the fundamental principles of India, And by this, they've tried to narrow the public policy context that was previously being used in appeals, and they've even defined under fundamental principles what that means. So it completely narrows the opportunity for arbitral awards to be challenged in court. That doesn't stop a party from actually, just bringing a challenge, even if it were not a very serious ground. But it remains to be seen how the courts are going to interpret it, whether they're going to interpret it narrowly or widely.
I mean, that may well be the position under Indian law, but under English law, it's very clear that you have a very limited statutory right of appeal, which is limited to points of law and procedural irregularities during the arbitration. But there is nothing, in the light of your question, there is nothing stopping, and one sees this all the time, there is nothing stopping the parties to agree that there will be no appeal, in which case, if you once you've had your arbitration and the award, it will be final and binding, and there will be no court applications or appeals in respect of it. On the other hand, by the same token, if you feel that you want to appoint a different body to have some form of appeal jurisdiction, freedom of contract means that you're entitled to say that you want any court, courts of India, courts of Mauritius, wherever you like. Whether that court will accept jurisdiction is another matter, but the parties can seek to confer it on other parties. But of course, in international commercial contracts, it would be very unusual for the parties to want to enlarge the ability of an appeal beyond at least what the statutory rights are.
So the position on Indian law would be a little different here. So Sahil, the question that Sahil posed was whether you can have a clause which says the award shall be final and binding.
That's correct.
However, the parties cannot appeal or challenge the award. Now, this is clearly struck out by Section 28 of the Indian Contract Act, which says agreements in restraint of legal proceedings. And such agreements or such clauses which say that the award shall be final and binding and the parties cannot appeal against such an award is going to directly hit Section 28. So such a clause will not really be enforced. In fact, there is a direct judgment of the Supreme Court in Shin Satellite case where the Supreme Court has employed the blue pencil rule and has specifically struck out just this portion which says the parties cannot appeal or challenge this award. So the blue pencil rule is also one rule of interpretation of contracts where the courts try to enforce majority of the contract, and if the court can sever only the offending parts of the contract, such as this line which says that you cannot challenge the award, it will try and strike out with a blue pencil this part of the clause and retain the majority of the clause. So the idea is to uphold the contract as much as it is enforceable, containing and retaining the valid attributes of the contract. However, any technical or trivial parts which attempt to hit the clause can be struck out using the blue pencil.
I think there's a distinction also, though, to be drawn between the substantive merits of the award, which under English law you're free to either expand or to restrict and do away with all rights of appeal. And there's a different position in relation to challenges to the award. Because I think in relation to challenges to the award, for example, any complaints about lack of jurisdiction or any complaints about the enforceability of the award, for example, there may be some public policy grounds under the New York Convention, that's not something that the parties are able to just simply do away with. So I think it's very important to bear that distinction in mind between the substantive merits and issues that go to the enforceability of the award.
That's absolutely correct. It's important to distinguish between two different concepts over here. One is the concept of multi-level dispute resolution, where you have one arbitration going into appeal to a different arbitration or something like that. That is something that has been recently upheld by the courts in India. Another aspect is what is the remedy available to a party that is sitting on an arbitral award when the contract itself says that the award is final and binding and parties will not file any appeal or challenge from it. Now, when you are sitting on an award, you have the option to go enforce it, and if somebody is aggrieved by it, they have a statutory right under 34 to be able to file proceedings to have that award set aside. It's not in the nature of an appeal. It's specific setting aside proceedings where a court will have very limited grounds on which it is supposed to look at that kind of an award. Now, traditionally, Section 34 was considered to be very wide. Courts have consistently narrowed it down. Karishma is absolutely right when she says that in the 2015 amendments, it was narrowed down even further. And in fact, the amendments went so far as to distinguish and create one more threshold, which is international commercial arbitrations which are seated in India. While they were earlier treated on the same footing as a domestic arbitration, by virtue of the amendments, they will now be treated on a different footing. And the different footing is that the specific ground of patent illegality, which is applicable to domestic arbitrations, is something that will not apply to international commercial arbitrations that are seated in the country. So that is the broad difference between the two.
I would just like to make an addition to this question, to your question, that if the parties itself have consented to the order of arbitration, then I don't think at a later stage they can go for an appeal. But there are certain grounds in the Arbitration and Conciliation Act itself that these are the grounds where we can set aside the award and we can move ahead.
It's very, very rare to find a party that is willing to accept an arbitral award and respect it. If somebody wants to challenge it at any given point in time, or somebody wants to at least resist the enforcement of it.
I mean, I think this raises quite an interesting philosophical issue about the nature of and the extent of freedom of contract, which those involved in commercial contracts will say, well, you should be able to agree to relinquish any challenges and keep the sanctity of the award. But against that, arbitration itself is not a self-contained galaxy that can exist without the support and within the context of the court systems, where arbitration is either supported at the pre-arbitration stage, during the arbitration stage, and then at the enforcement stage. And the law in the New York Convention has recognized that there are certain immutable grounds under which the courts of any state party is entitled to refuse. And it's the courts that are refusing, on, for example, public policy grounds, to refuse to enforce. And the philosophical issue is, at what point do you draw the line where you say freedom of contract cannot extend and the public interest of a state and a courts of a state will not relinquish the right to say we will not accept the enforcement of an award. There is that distinction, but I think there can be arguments about where that dividing line is.
And I think it's not a line that is cast in stone. It is a line that is fluid, it's moving, and it certainly depends on the sensibilities in every jurisdiction. What's good for the goose is not good for the gander. So
we've recently seen that in the Tata Docomo judgment, and this really throws up a very serious issue, which is when you have an arbitration seated in one country and you have an award that would be legal in that country, but when it is brought to another country for enforcement and an aspect of that award is against the law of that country, in this case it was the FEMA regulations and foreign exchange, and also the not the transfer pricing, but the price at which one could exit and a foreign entity could exit the joint venture. And what does the court, where it has come for enforcement, do? Does it uphold this award, which was otherwise legal under the jurisdiction where it was actually conducted, the arbitration was conducted, or does it stop the enforcement on the grounds that it is against and illegal where the court itself is situated? And I wonder if any of you have comments on that. I heard, though, Justice Sundaresh Menon, who is the Chief Justice of the Singapore courts, and he made a very good point, and he said when parties go to arbitration, they are well aware that they want to have the dispute finally settled and resolved, and they don't want to go to court. They've chosen to go to arbitration for the resolution mechanism that arbitration has, and therefore that should just be upheld. And that was an interesting take on the philosophical point that Jasbir raised.
very philosophical, and I'd agree with that approach. At the end of the day, if you enter into a contract to resolve your disputes in a particular manner, go forward, do it, and respect the decision that comes out. And whatever options are left available to you at the end of it, so be it. Shama, would you like to talk anything about Tata Docomo?
Well, I have some mixed views that I've heard. But I personally feel that the public policy, it has been quite nicely put in by Justice Bhagwati himself, that public policy is an unruly horse. So, what is really public policy in India might not be public policy elsewhere. And it really depends on where you are trying to enforce the award. Now, when you come to India, public policy is really, really strong, and it's quite subjective. So, it's a good decision that it has come here, but I think public policy is a very, very fluid ground, and when you try to attack enforcement of an award on that ground, it can really go either ways.
In case of a court-appointed arbitrator, there is a delay, inordinate delay, mainly because of the arbitrator. So, what recourse would be available?
Oh, the world in sorry.
Yes, no, sorry.
The world in respect of delays has changed after October 23rd, 2015. Once the amendments have now come in, any arbitration that has been invoked thereafter is expected to be completed and an award obtained within a 12-month period. If parties agree, they can agree on an extension of 6 months. So that takes you to about 18 months. At the end of 18 months, if you need an extension beyond that, you need to go to the court and demonstrate why you have not been able to get an award in 18 months. Now, obviously, there will be some arbitrations that are heavy, intensive. Obviously, there are some sort of delays. And if good reason is shown, the court will grant you that extension. If there are no good reasons shown, and let's assume that one of the parties is delaying or procrastinating, or let's assume that the arbitrator in question is a very busy man and is not able to give you time, then the court has the power to, number one, impose costs on that party, number two, change the arbitrator, number two, knock off the arbitrator's fees. The court now has a lot of power. We are yet to see how that power will be exercised. But to now have it in statute where parties can go to the court and keep the conduct of arbitration under check is something that we hope will work towards improving the general ad hoc arbitration scenario in India.
And we also have the Sri Krishna committee report that has just come up, making recommendations for further amendments to the Arbitration Act. One of the key recommendations is removing the time taken up by filing of pleadings from the entire 12-month period, and suggesting that 6 months should be granted for submission of pleadings, and thereafter the time or the clock will start ticking for completion of the arbitration. So as Sahil said, we are yet to see how these things are going to play out. The costs follow event regime where the court is going to look into whether it can extend the mandate of the tribunal beyond 18 months, or whether the legislature will take in the recommendations of the Sri Krishna committee on extension of this 12-month rigorous deadline, added by 6 months by party consent.
Just to keep in mind, like Justice Sri Krishna is an eminent jurist. He has tremendous experience and he has a large number of arbitrations. So when a solution comes from him saying that, look, you need to give a little bit of time for pleadings, after which let the clock start ticking, he comes from a place where he sees how the law is affecting arbitrations on a day-to-day basis. Now, what we see as Indian advocates is that when you go before an arbitral tribunal, everybody in that room is conscious of Section 29A and the timelines imposed. Everybody is making conscious efforts, or at least making the right noise to adhere to those timelines. So things that would normally, you could walk into an arbitration and say you want 6 weeks or 8 weeks time to file your statement of claim. Those days are gone. The court says the arbitrator says you have 3 weeks or 2 weeks or maybe even 4 weeks. But he gives you your schedule on day one today. The fact that everybody is so conscious, the parties, the arbitrators, the lawyers, are so conscious of timelines only demonstrates that this Section 29A timelines has worked as shock treatment for Indian arbitration. It's something that was possibly required. Now, maybe it's a little bit too much. It's a little bit too much to digest so soon for a lot of people. Probably the courts will be a little lenient when it goes to them for applications, or at least until the law changes. But having said that, as legal practitioners, I think each of us is happy that the justice redressal system is working as it should be. And yes, it makes us work a little harder, but if parties are able to resolve their disputes, so be it.
So
There
but
is
this Arbitration Amendment Act, this 2015 with 12 plus 6 months, is applicable to all new arbitration, or will it applicable to existing?
No, new. After the 23rd of, it's a prospective amendment. So after the 23rd of October 2015. And it specifies when you make an application for the appointment of an arbitrator to court, it specifies the number of days. I think it's 60 or 90 days. I think it's 60 if I'm not mistaken. And the court must appoint a arbitrator by then. And it's even, there's a policy, there's a circular, or there's a judgment now of the Supreme Court which allows arbitrators to be appointed not just by the court but also by arbitration institutions such as the MCIA. And by that, they want to reduce the amount of time taken to appoint an arbitrator.
I have a question getting back to interpretation of contracts for Jasbir. So we have certain judicial rules of interpretation of contracts. We have the contra preferentum, where if a contractual provision is ambiguous, the courts will generally try and get a meaning that is preferred against the drafter of that contract. So that's contra preferentum. Or we have the aegisdem generis rule. Can the parties by contract opt out of these judicial rules of interpretation? We are seeing a scenario where business parties are not just commercially sound today but legally sound as well. So we have certain internal interpretation clauses in contracts which say the contra preferentum rule will not be applicable. Or let's say the aegisdem generis rule will not try and limit a general statement which enumerates a list of specific items and will also include other items. So how have courts really enforced such kind of internal interpretation clauses, ruling out judicial rules of interpretation?
The short answer is you can contract out of these rules, and often you see commercial contracts which have these provisions that say that the contra preferentum rule shall not apply to the interpretation of this agreement, and an English court in that scenario would enforce that clause. But what the premise on which that question and that clause is based is the assumption that if that clause wasn't there, the English court would indeed apply the contra preferentum rule or the aegisdem general rule. But there are, I think it's very important to understand that the 6 general principles that I've outlined are general principles about the general approach to interpretation. What the task is, what the evidence is, and how you go about approaching interpretation. There are numerous what you call rules, but really are sub-principles of interpretation, of which the contra preferentum rule is just one rule. Another principle is that the court will strive to interpret the contract so that it validates and upholds the contract rather than adopting an interpretation that invalidates the contract. You can go on and on and on with these list of rules. There's a textbook in England called The Interpretation of Contracts, written by a current sitting Court of Appeal judge called Lord Justice Lewison, and it's a 300-page book with all of these principles and application of these principles in there. But the critical question is, in the commercial contractual context, because that's what we're talking about. We're not going to be talking about consumer contracts, because in consumer contracts there is a mismatch in terms of bargaining power. and courts will often, before the modern intervention by statute, courts use things like contra proferentum to protect the weaker party. That protection is no longer necessary in the common law because we have very strict regulations and statutes that protect consumers where there's weak bargaining power. But in the commercial context, both sides are commercial parties and they should be strong enough to protect themselves. And in my 24, 25 years of practice, I have not seen either a New York judge, an English judge, or any other arbitral tribunal applying English law, or I believe any other system of law, ever actually applying the contra proferentum rule in order to resolve an issue of interpretation. And I think the reason for that is partly what Professor Wigmore says is we've shifted from superstitious formalism to a flexible rationalism, partly because commercial cases, the bargaining power may not be identical, but it's broadly similar, so courts don't need to protect. And thirdly, most importantly, courts and tribunals, they want to come up with what they think is the right answer to the interpretation of the contract, applying these general principles, rather than saying, well, it's 50-50, we'll flip a coin and the contra proferentum rule will mean that, one party trumps. I mean, one of the difficulties is working out who the proferens is in many of these cases. We've got a contract, which is not a standard form contract where one party has drafted it all, but where you've got an exchange and a give and take and you've changed a few clauses here, changed a few clauses there. Well, why is one party the proferens rather than the other? So I think in practice, my experience is the contra proferentum rule has really gone into desuetude. It's just not used anymore. And you can have the clauses in your contract that say no contra proferentum rule will apply, but I don't think they will be applied anyway.
Okay, thanks.
So, Jasbir, as you said that there is a flexibility in applying applying the agreements, the clauses in the agreement. So, I have a different view that in India there are number of statutes, number of acts, but there is one common underlying principle that it cannot be ultra vires to the constitution, being constitution as the base. So if we look it into the agreements, the interpretation of statutes is the base for preparing any agreement. So how can I go against the principles of interpretation of statutes and I can be flexible in contract, in placing an agreement?
I think that there are similarities between the interpretation of contracts and the interpretation of statutory instruments and legislation. So the principles that Lord Hoffman talked about, starting off with the ordinary meaning, looking at the context in the situation when you're dealing with a statute, often you can look at preparatory material, legislative material, you can look at debates about the statute in order to try and glean what was the purpose behind the relevant statute. And you've also mentioned constitutional issues where ultimately statutes need to be tested in terms of their constitutional validity against the Constitution. Commercial contracts are not exactly the same as statutes, because obviously you're not talking about constitutional validity when you've got two commercial parties, and the question is, what does the contract mean? So I think in that context, I think there are some similarities, but you can't go too far. And I think there is a body of law where statutory interpretation departs somewhat from commercial contracts, because ultimately with statutes, one is asking the question, what was the intention objectively of the legislature? But when you're looking at a commercial contract and you're saying, what was the intention of the party? Issues such as certainty, predictability of meaning are far more important in a contract than they are with a statute. Of course, a statute needs to have a certain predictable meaning, but not at the expense of the individual rights of the citizen. And so I think that there are different considerations, and so it's not wholly desirable to elide the two.
It's important to keep in mind that statutes operate in rem. They operate against the world at large, or at least the country at large. Contracts operate in personnel against the parties to it. They don't operate against others. That's a very important characteristic. And also the mischief rule. What is the mischief that was sought to be remedied by the statute? That doesn't really apply to the contract. In contract, it's about what's the commercial bargain of the parties and what was the intention of the parties in entering into that particular commercial understanding. And it is that understanding that needs to be interpreted by the court and given effect to. Keep wearing the hat of a commercial man. I think.
One last question.
Of course.
I'm not a lawyer, I'm a medical practitioner. Just throw some light on Malia's case and entertain us a little bit to end with
extradition. Right. I mean, one doesn't know where to start as far as this is concerned, but there are basic principles, again, as we have for interpretation of contracts and we have for interpretation of jurisdiction clauses. The basic principle in this case is that of dual criminality. So when under the India-UK extradition treaty, this principle is recognized, which means that it must be recognized as a crime in both countries for that person to be extradited. So for example, capital punishment is not recognized in England, but it is recognized in India. And if someone is subject to or may be subject to capital punishment for the crime that they have committed, that person cannot be extradited out of the UK because dual criminality fails. It's not recognized in both jurisdictions. So there is also another case of the rule of speciality, which is that if someone is extradited, then they can only be tried in the country that they come back to for the case that has been described to the country that they are extradited from as the problem. So for example, if someone is extradited for a loan default, they cannot then be tried for an enforcement directorate proceeding unless that was also brought within the notice. So that's the rule of speciality. And in the case of Mr. Malia, I think the biggest hurdle is likely to be that there must be a jail term of at least 1 year, when the person is extradited back. And I haven't studied in detail the ED or the CBI files, but if there isn't a jail term of 1 year, it's going to be difficult to extradite him. Let's not forget that of the few hundred extradition applications that India has made to the UK, only one person has been extradited, and that was for a terrorism crime. And there is another pedophile who also has not been extradited. So when we compare those kind of heinous crimes to loan defaults, we're speaking about two different perspectives altogether.
So what are the ways in which Indian government can try to extradite him, if not considering it as a criminal case in UK?
Well, they are doing what they have to do, which is they're building, in my opinion, they're building all of the evidence that is required to bring him within a 1 year jail term. So they have, therefore, in my opinion, initiated ED and CBI proceedings, which otherwise would not be necessary. It's a simple loan default. But they need to do that to be able to give the criminal angle to it.